Miley & Brown en Dallas, Texas, hace casos de migración, de pertenencia de la familia, de deportación, de asilo y de negocio. Muchas familias tienen preocupación de separación de la familia, de casos de cuando no tienen trabajo y casos de negocio. Primeramente, darle un resultado positivo, oír sus problemas de sus casos y siempre mantenerlos informados en su caso. Cuando trabaja con los abogados de Miley & Brown, espera que tengan los abogados experiencia en casos de migración. Estamos aquí para ayudarles y apoyarles en todos los casos de migración.
FindLaw LLC will help a small business owner through all phases, from startup, such as choosing the business entity, through the going concern, changing forms if necessary, through the liquidation or wind down, whether the business is going to be sold or liquidated. Each client brings a unique set of circumstances into the office, and therefore the approach that FindLaw takes toward each client is equally unique and tailored for the needs of that particular small business owner. FindLaw is the smart choice for a small business owner because not only do I have my law degree, but I also have a Master's of Business Administration from the University of Miami in finance and computer technology. By having those two degrees together, I am able to bring a comprehensive understanding of business to the table, in addition to my understanding of the legal aspects of it. And my representation is more comprehensive than merely that of an attorney.
The effective drug and device law is a constantly changing field in that we don't know what folks are going to push to market next that is going to be dangerous and result in injury.
The medical drug and device industry is profit-driven.
It is more important to get this product to market and make that money than care about what might happen to the people who have purchased this product.
We don't have the kind of population that a state like Texas or New York or California has. So when a defective drug or a defective medical device is put on the market here in Iowa, it may not result in harm to enough patients where they could get together as a group and try to hold that drug manufacturer accountable. And what we bring to the table here is we work with a network of attorneys nationally who can bring all these cases together and stand up to these big drug companies and device manufacturers.
We give Iowans a voice at the table to make sure that they are properly represented and that they receive proper compensation, that their stories are told, that every aspect of what has happened to them because of a defective drug or device being pushed to market is heard by the folks who caused those injuries.
Products liability cases can be extraordinarily expensive. So over the years, because these products have when they tend to cause a problem, the problem is widespread. It's throughout the United States. They developed a system in federal court to bring these cases together for discovery purposes, and that's multi-district litigation. We combine our resources. We have access to some of the best legal talent in America who began to expose the problems with the product. The objective of it is ultimately to let the defendant see that he has a bad product. He can go try 5,000 cases. He will lose 90% of them. So he should do the rational thing, which is to come in and get everybody's case settled at a reasonable sum of money so that the folks who are injured by the product can get on with their lives.
I've been practicing workers' compensation law for over 25 years. I've never represented an insurance company. My practice is limited solely to defending the rights of injured workers. Most people go through their career without ever being injured on the job. When someone is injured, they really don't know how the system works. The law can be very complicated and difficult to understand. The approach we take at the Ely Law Firm is to address the injured workers' concerns right away. When someone's injured on the job, the one thing they have on their mind is recovering from their injury. They want to get better as soon as they can. They don't need the additional stress of worrying about how they're going to be treated at work. They don't need the additional stress of worrying about if they're going to be able to go back to their old job. They don't need the stress of worrying about how to pay their bills. We try to address those issues right away and get the benefits flowing to the injured worker as soon as possible. When a client leaves the Ely Law Firm after meeting with us for the first time, they understand how their case is going to proceed. They'll understand what we're going to do for them, and they'll understand the benefits that they're entitled to. Defending the rights of injured workers is the only kind of law we practice at the Ely Law Firm. Permanent partial disability are benefits that are paid for a permanent injury where the injured worker is able to go back to some type of employment. The amount of permanent partial disability benefits an injured worker receives is not based upon whether or not he can go back to work at his old job. It's based upon a rating that the doctor gives you. For that reason, our firm wants to make sure that you receive the maximum benefit to which you're entitled. The doctor that gives you your disability rating is usually the doctor that was chosen by the employer. You may be dissatisfied with the rating that that doctor gives you, and if you are, you can get an independent medical examination. If the parties can't agree to a doctor, the Division of Workers' Compensation provides a list of 3 and each side crosses off one. You're left with the one that remains. The insurance company is very aware of who these doctors are, and so is the Ely Law Firm. If you're considering going through the IME process, contact us. We can help you in selecting your doctor. At the Ely Law Firm, one of our jobs is to reduce the stress that an on-the-job injury causes to a wage earner and his family. At the Ely Law Firm, we work to maximize the benefits you receive and to take into account all the sources of income that you've lost. When you're injured on the job, you might feel that the insurance company is on your side. But if you're just talking to the claims adjuster, you may not be fully aware of the benefits that you're entitled to. For example, if you're unable to return to work, you're entitled to 2/3 of your average weekly wage. But what you're often not told is that includes your overtime, and if you're working a second job that you can't return to, it includes the wages you would have made there. It also includes such things as room and board and lost insurance benefits. This is probably your first experience in the workers' compensation system. You need to know that the claims adjuster is in an adversarial relationship to you and has many years of experience and does this work every day. This difference in experience can put an injured worker at a real disadvantage. At the Ely Law Firm, we use our experience to level the playing field so that you get the benefits that you need. It's important that you receive all the medical care necessary for a complete recovery. At the Ely Law Firm, we're dedicated to making sure you receive the treatment that you need. Frequently, an injured worker is told by his doctor that there's no more treatment that can be offered. That can be a real concern if that worker still has restrictions and is unable to return to his job, or if he still has pain. When the treating doctor tells the injured worker that no more treatment can be offered, we schedule an independent medical examination. If the independent medical examiner states that there is more treatment than can be offered, we fight so that the claimant can receive that treatment. If your injury worsens and your case has been closed, you can reopen your case and receive additional medical benefits as well as temporary and permanent disability benefits. One of the most important benefits available to you in the workers' compensation system is medical treatment. If you have questions about any aspect of your workers' compensation case, please call us. We'll provide a free consultation.
The intention of the wills variation provisions of the new Wills, Estates, and Succession Act is to permit the court to review a will maker's will, and if the court is satisfied that essentially that the will is unfair, that the will maker has not carried out his or her moral obligation to the spouse and children, to vary the will, to provide adequately, justly, and equitably for the disinherited spouse or the disinherited child or children. And the result has been that adult, independent, but disinherited children have historically been given a remedy under the statute. A lot of people, I think, believe that will makers have freedom of disposition of their estates, and by and large, that's true. But there is this overriding supervision that the court has under the wills variation litigation to rewrite wills where the testator has not lived up to his or her moral obligations to a spouse or to a child.
We all see many other drivers using their cell phones while driving. We see them texting, we see them placing calls, updating their Facebook status, and we know that texting while driving is just as dangerous as driving while under the influence of alcohol. If you've been injured by a distracted driver, chances are they will deny using their cell phone. It is important then to enlist the help of an attorney in order to properly investigate whether they were on the phone, whether they were using social media, because we're able to request a police report, which will often cite whether the other driver was using a device. We're also able to request cell phone records that will allow us to prove, yes, they actually were distracted.